Hello everyone, I'm George from Ireland. So this video is about homicide, that's to say killing human beings. The homo as in man, but could mean human in Latin, and sidere as in to kill. You find it in suicide, genocide, fratricide, infanticide, sororicide, democide, parricide, matricide, and so forth. Okay, so someone has got to be killed. This has got to be a human being who's outside the womb. If a fetus or an embryo is killed, that's sometimes legal under the Abortion Act, sometimes it's illegal. But even if you illegally kill a human fetus, that's not murder, that's another crime. But won't go into that. So anyway, so there are other types of homicide, which is there's manslaughter, broken down, very complicated. There's voluntary manslaughter, which is subdivided into loss of self-control manslaughter, diminished responsibility manslaughter, or suicide pact. There's also involuntary manslaughter, and again that's subdivided into reckless manslaughter, gross negligence manslaughter, and constructive manslaughter. And if that seems incredibly complex, well, it is. So this is one of the trickiest aspects of criminal law. There's also justifiable homicide, which is not a crime. So deliberately killing someone can be entirely lawful. If you have a valid defence, such as you're a police officer, the London Bridge attacks a few years ago, some terrorists had shot and stabbed a dozen people. The police came along and they shoot dead the armed terrorists. That's it. I'm not sure if they called upon them to surrender or not, but these people have already committed several murders. There's not a moment to lose. The longer you leave it, the more people they're going to kill. You've got to kill them. There could be other situations, a hostage situation. The guy says, I'm going to shoot dead the hostage. I'm going to kill her. I'm going to count down to 10. 10, 9, 8, 7, and the police marksman shoots him dead. So that would be an example of justifiable homicide. Or a soldier killing an enemy combatant in war. That would be justifiable homicide. Or if somebody is attempting to kill you and you fight back and then kill the other person, again, that's justifiable. Okay, so let's go into the various types of homicide. It's got to be an unlawful killing. So a killing is lawful if it's accidental. If it's not blameworthy, right? Then the valid defences which can operate are the ones I already adumbrated. So if you kill someone with that person's consent, that is no defence, right? So euthanasia, as in derived from the Greek for good killing, is not allowed in the United Kingdom. It is permitted in the Netherlands, Switzerland, and some other jurisdictions. So anyway, the principle it was laid out here in Nicholson 2014. So Nicholson was suffering from locked-in syndrome. He could scarcely move due to strokes. So he was really paralysed except for his eyelids. So he could communicate, blinking. They worked out a code for him to blink. This means yes, this means no, whatever. But anyway, he wanted to be allowed to die and for his wife to kill him. He wasn't capable of doing anything, couldn't do things with his hands, couldn't put anything into his mouth. It had to be administered to him, a poisonous substance, because he said his life was simply unbearable. Anyway, he said his human rights were taken away because since he had no independence, he was utterly paralysed. Just about how horrific that was. Anyway, make you count your blessings, realise how lucky you are to be healthy if you can move your body. So he wanted his wife to be allowed to kill him. So the Supreme Court said they're not going to permit that. That's up for Parliament to legislate on this. So the European Court of Human Rights reached the same decision. That was in Nicholson against the United Kingdom admissibility. It was heard in 2015, because this is a highly controversial matter, and the judges mustn't stray into the political arena in legislating on something that must be left to the legislature. So anyway. In Canada, for example, their Supreme Court said that doctors can assist suicide under certain circumstances. We won't go into that. So anyway, a person has the right to refuse medical treatment. An adult of whose compos mentis can do so. So and that can lead to the person's death. The doctor's not responsible. You know, even a young woman who was 18, had cancer, didn't want the chemotherapy. Okay, but if you don't have chemotherapy, you're likely to die in a few months. I don't want chemotherapy, right? She was allowed to die. Anyway, And there was a situation where a woman, she needed an emergency cesarean section, otherwise she's probably going to die. She refused it. The doctors performed it without her consent to save her life and that of her infant. But that was held to be illegal in St George's Healthcare NHS Trust against S. So there we go. Is that the right result? Can we be happy with that result? That woman willing to let herself die, all right, but she's also willing to have her baby die. Now the UK allows abortion, so but should it care about babies, especially right at the end of the pregnancy? This is a fetus that's 9 months old in the womb. Anyway, so as I said, homicide can only be committed against human beings. Killing somebody else's pet or something is a crime, but that's criminal damage. These are regarded as property. So let's look at mens rea. For murder, going to murder. So mens rea here is the guilty mind, the wanting to kill someone or at least to cause grievous bodily harm. And there's malice of forethought. You've thought about it beforehand. Okay. You don't have. So if you did something in the heat of the moment, that's murder. It's not just if you planned it beforehand. Okay. So Inglis 2011 was a case about this. This boy was in a persistent vegetative state. So his mother decided to help him, as she thought it, by giving him a fatal dose of heroin, but nevertheless that was still murder. So the mens rea is wishing to kill someone. We call it express malice here, or indeed to cause grievous bodily harm. We can be called implied malice. So again, what is intention? So you must intend there to be death or grievous bodily harm. So sometimes the judge will say we can find an intention even if we don't think there's a direct intention there. So the jury has to think, did the defendant know that death or grievous injury was likely to occur? If so, they could well find, yes, there is the mens rea. So criminal law, it really matters that the judge doesn't misdirect the jury. Then it can be said to err in law, could be a mistrial, could be an acquittal on appeal, things like that. Anyway, so how's the jury directed on mens rea for murder? In most cases, they follow the ordinary definition. Remember, intention and motive are not the same thing. Intention is an ordinary English word and shouldn't require any explanation. This is what an ordinary definition would be. Find the defendant guilty of murder. You must ask, did the defendant attack the victim with the intention of killing? And are you sure they had this intention? Did the defendant attack the victim with the intention of causing serious injury? If you say yes to either of these, then you can convict the person of murder. But if you're not sure, you must acquit. Okay, so anyway, let's look at Woolen 1999, which I mentioned before. So the jury had to think, what was the defendant's intention in throwing the victim off the roof? Was it to kill the person, cause serious injury, or teach him a lesson, or give him a great fright? Now you might think that's nonsense. You might think, well, no, he really did push him off the roof with the intention of giving him a fright. But surely the guy was at least reckless to the possibility that the victim would die or suffer grievous injury by being pushed off the roof. So if so, you could still find the person guilty. So juries usually convict of murder when there's a direction, when they think that there's no doubt or they're almost certain. They can impute knowledge to the defendant that he knew the death or grievous injury was likely to result. So they then have to have foresight of certainty. It can be probability. So that's a little bit about murder and intention. So the jury, they have got to think about these things carefully. It's a high conviction rate for murder because this is something that the police are so careful when preparing, and so are the Department for Public Prosecutions. So think about what was the defendant's intention in what he did. All right. So they have to think, yes, that the defendant, he wished to kill or cause grievous injury. He was at the very least indifferent to whether this was going to cause a grievous injury or death, and anyone would know that there was a high chance that at least grievous injury would result from what he was doing to the victim. So the thing is, the jury are not obliged to find intention. They're not obliged to find there was a foresight of certainty. They can find that if they wish to. They're not forced to find so. Okay, so the juries can reduce a charge to manslaughter, saying the killing was not done recklessly. It might have been a justified risk-taking. It was not unlawful. There was no wish to harm someone, or it was no recklessness about harm, or it wasn't indeed grossly negligent. It might have been reasonable behaviour in that situation. So there are other ways to get someone acquitted of murder. There could be a defence of necessity, as the defendant had to do what he did. The courts have not developed a broad defence of necessity. So it's up to the jury to think, well, does this vitiate a mens rea requirement? So if the defendant uses a deadly weapon, like a knife or a gun or something like that, if he uses a noxious substance or very heavy violence, as in kicking many, many times, then the usual definition will suffice, and they don't need to refer to the Woolen case. So I have to underscore again that mens rea for murder is a intention to kill or to cause grievous bodily harm, and that was laid out in Vickers 1957, Cunningham 1982. In the latter case, the defendant hit the victim many, many times on the head with a chair, and that caused death. Now, a chair is not a lethal weapon, but anybody would know that using this sort of heavy item on the most important part of the person's body could easily cause grievous bodily harm or death. Anyway, so the defendant said, launched an appeal, said that the Vickers case was wrong, but no, the court said Vickers was correct. All right, so the jury have to look at intentional violence. So sometimes the jury are directed here. If the defendant occasions someone's death by an act of willful violence, the jury can say, well, that wasn't actually intended to be life-threatening. Anyway, so, using an iron bar or something just once might not be intended to be life-threatening or even to cause grievously bodily harm. So someone might get away without being convicted of murder there. So the judges have got to say to the jury, you ask yourself, did the defendant act with the intention of killing the victim? And if you're not sure, then you'll have to say, did the defendant do this intending to cause grave injury? And if you want to say, if you say yes to that, you can still vote guilty. So the prosecution don't have to convince that the jury that the intention was to cause a life-threatening injury. It's sufficient to prove that it was meant to be a very serious injury. If it was intended to be a minor injury, all right, acquit. If you're hitting someone in the legs, it's hard to see that was intended to be life-threatening. Okay, so the law on murder has changed a bit over time because the legal profession was often unhappy with the way it was. The main problem here was a mandatory life sentence. So a thrill killer who killed dozens of people would get the same sentence as say, a wife who helped her husband who was suffering in agony. They get the same sentence, but then they get the tariff is what they're actually going to serve, which is ridiculous. Life almost never means life without parole. Even when they're held to be terminally ill, when it's estimated they've got under 3 months left to live, they're usually given benevolent parole, the Cray twins. Of course, how long they've got left to live is difficult to say. Like take the al-Megrahi case, 2009, he was released. The Pan Am bomber, that Libyan chap was convicted of putting a bomb on a Pan Am flight from London to the United Kingdom, which blew up over Lockerbie, the Lockerbie bomb, murdered something like 300 people. So the largest mass murder case in British history. But he was dying of cancer. They got an oncologist to estimate he had under 3 months left to live, and so he was released. He actually lived for 2.5 years, got a new lease of life when he got home to Libya. So some people get a very ridiculously short tariff. Tony Martin released after 3 years after a murder conviction. We'll come on to his case a bit later. Many commentators say it should be enough for murder that there's constructive liability. And there's liability for a more serious crime, murder, and that's constructed out of the aspects of the lesser crime, which is causing grievous bodily harm with intent. So remember the correspondence principle. Okay, So Lord Stein talked about this in Powell and Daniels, a 1999 case. Come on to voluntary manslaughter. So there are various defences, and there are three special partial defences, and any of these could lower the charge from murder to voluntary manslaughter. Voluntary manslaughter is so called because the prosecution must demonstrate the killing was voluntary, as in the person intended to kill or at least cause heavy violence. But there is some mitigation here, which means that a mandatory life sentence would be unfair. Okay, there's a loss of self-control. We used to call it provocation until 2010, and the other one is diminished responsibility. So provocation. So in this case, it's about killings before 2009. That's what they used to say, provocation. So, or loss of self-control, as we say these days. So they're quite similar. So there's an objective and a subjective part to this. The subjective part is that the killing was consequent on someone losing control of himself or herself, and this is caused by the actions or words of the victim. The loss of self-control, which has not been caused by the victim's words or deeds, is no defence, as per ACOT 1996. So we need to prove that there's a loss of self-control, and this cannot be vengeance. That's no defence, or can't be anything which is planned in advance, as per Ibrahim's 1982. So the defence can't be relied upon. Usually thought it can't be relied upon if there's a long time gap between the provocation and the slaying. Okay, as per Duffy 1949. Ahluwalia, 1992, was a case where a woman was in an abusive marriage, beaten up by her husband many, many times. After several years, she put poison in his food and killed him. So feminists came to her rescue saying, oh, well, murder of your husband's all right in these circumstances. And people say, well, murder is murder. Okay, he's a very bad man, but he wasn't trying to kill her. Leave him. Go to the police. Something. Don't kill him. And the feminists, all right, they weren't trying to legalise murder, but they're trying to say that she should get a light sentence. There's a loss of self-control, and it's found from Ahluwalia that it doesn't have to be an instant reaction, because he hadn't hit her that minute, that hour, maybe even that day. Might have been days since he'd done something, but the idea is she finally snapped. So this is going to be slow burn. And these days, the Ellis case, 1954, probably was treated in the same way, as had Ruth Ellis, the last woman hanged for murder, who shot dead her abusive boyfriend. Anyway, we'll look at these various defences. The objective element was the way the person's behaviour should be, which should be the way a reasonable person would behave if they're faced with the same situation. We have to take into account the particulars of the defendant and what the words and deeds that were done to that defendant, the person's age, race, sex, weight, or whatever. Was it a racist insult? Was it a very weak man who loses his temper with a very strong man? Well, that might well be a real case of provocation, because a weak man is not going to attack a strong man if he is his right mind. If he's really lost it, then he would attack someone who's much stronger. But if you are very muscular, attacking someone who's very feeble, well, that's hard to see as provocation. You're attacking him because you know you can beat him up quite easily. It could be to do with sexuality, someone's sexual orientation being insulted, and so forth. So the jury must consider the characteristics which would have lowered the defendant's ability to control himself below that of reasonable people. Well, but they can't take into account intoxication. That can't help your defence. Mental illness, no, or if the person's a particularly volatile personality. So let's look at loss of control. The Coroners and Justice Act 2009. It keeps this doctrine of provocation, though, as I say, we now call it loss of self-control. But it restricts the number of qualifying triggers there are that a defendant could use. Beforehand, defendants use this defence in cases which were now regarded to be invalid. They shouldn't be allowed to do it. For example, was annoyed by an infant crying, by your partner just nagging you all the time, by someone committing adultery or something. These defences shan't operate any longer. Okay, so Section 54 of that Act says, 1. Where a person, defendant, kills or is party to the killing of another, victim, the defendant is not to be convicted of murder if A. the defendant's acts and omissions in doing or being party to the killing resulted from the defendant's loss of self-control, the loss of self-control. B, the loss of self-control had a qualifying trigger. And C, a person of the defendant's sex age with a normal degree of tolerance and self-restraint, and in the circumstances of D, might have reacted in the same or similar way to the defendant. 2, for the purpose of subsection 1A, it does not matter whether the loss of self-control was sudden. Close quotation. So notice there's got to be a qualifying trigger. We'll come back to that. And also that an ordinary person might have reacted in the same way. We don't have to prove that an ordinary person would have reacted in the same way, only that he or she might have. Okay, so the subjective aspect of this is a subjective barrier that they've got to get over, the defence, the loss of self-control and the qualifying trigger. That's the thing that was done. So loss of self-control is not simple. So what does this mean? Duffy, 1949, in Judge Devlin said, well, the accused, and this is what he said, so subject to passion as to make him or her, for the moment, not master of his own mind. Close quotation. So cannot restrain himself. So it can't mean to him you lost your temper. It really, they just have no self-control. They're in a frenzy. They're just temporarily insane. The fact that it's disproportionate doesn't make this a valid defence in itself, as per R against Goodwin 2018. So the defendant who's killed whilst out of control, well, that can't be a revenge killing. And that is made clear in section 54.4. So if the defendant acted in a desire for vengeance, no, that's no defence. In Ahluwalia, as I say, it was proved that the loss of self-control does not have to be instantaneous. Okay, so this was a build-up of domestic abuse, the totality of which led her to kill her husband. Okay, R against Dawes and Hatter, 2013. The defence was not allowed to operate here because this was to do with the breakup of a relationship, and they planned it long in advance. So if it's the spur of the moment, that's much more likely to work as a defence. So let's look at qualifying triggers. So section 55.4, here it says, where the defence loss of self-control was attributable to a thing or things done or said, or both, which A, constituted circumstances of an extremely grave character, and B, caused the defendant to have a justifiable sense of being seriously wronged. Close quotation. So that's circumstances of an extremely grave character and caused the defendant to have a justifiable sense of being seriously wronged. Okay, so let's look at the first qualifying trigger. One could be fearing heavy violence. So the defendant fears heavy violence by the victim against the defendant himself or someone else. You know, the defendant thinks he's going to attack my child or whatever, or she's going to attack my grandmother or something. Okay, it has to be an identified person. Can't just be anyone, a random person, anyone in town. No, it has to be someone you actually know. So the usual situation is this. After an abusive relationship for a very long time, someone just goes crazy and kills their person who's been abusing them. So this can't be a desire for vengeance. It can't be a logical decision. So there's Clegg 1995 or Martin Anthony 2001. That latter one's better known as the Tony Martin case about a farmer in Norfolk. But I'll come back to that. So the defendants killed wrongdoers in circumstances where in both cases the defendants had good reason to fear for their lives, but then it turned out to be an overreaction. Many people say it's unfair that Clegg and Martin were convicted. So the defendant would say, yes, but in these extraordinary circumstances, it was so stressful, I was so frightened, I couldn't weigh up the level of force to use, and I just reacted in a split second, and okay, I got it wrong. But it's an understandable mistake. So this is a difficult situation. So using the self-defense successfully is difficult. A person who kills when he's been threatened with violence or another been threatened with violence could be a loss of self-control. So if the self-control defense doesn't work, there might be other defense, the other evidence they can adduce. As in R against Goodwin, 2018. Clegg was a soldier on patrol in Northern Ireland in the early 90s, 94, and so soldiers were being shot at all the time. But anyway, there's a checkpoint. Some people in a car burst through the checkpoint, don't stop, drive on. He fires at them and doesn't manage to kill the people. They go past him. He turns around and continues firing. And it was the shot after they'd gone past which killed them. And that said that, you see, that was it. Because they were no longer a danger. He was convicted for murder. People say, come on, so the first few shots here, a second later, they're past. And that's why he's convicted of murder. Some people think they're very unfair. What are soldiers to do? If he'd killed them when they were coming at him, he would have been in the clear, wouldn't have spent a day in jail. Tony Martin, some burglars burst into his house in 2000. He'd been robbed many, many times. It was dark. He fired. He killed one of the burglars, who turned out to be 16. A 16-year-old who already had 16 convictions. And that was Martin. So he only spent 3 years in prison, Martin, despite being convicted for murder. Some people said he ought to get a knighthood. Okay, so if a mother comes across a man severely beating her child, she may lose control and stab the person dead. So would this be a qualifying trigger? I think it would. Okay, let's look at the second qualifying trigger, where the defendant's loss of self-control is attributable to things said or done or both which A, constitute the circumstances of an extremely grave character, and B, cause the defendant to have a justifiable sense of being seriously wronged. Okay, extremely grave character. It's got to be something extremely insulting. It can't be just being annoying. It can't be weeping or whatever. It can't be sexual infidelity. Sexual infidelity is explicitly ruled out under section 55.6. It can't be one of these honour killings or something like that. So it has to make the person feel gravely wronged. They must be justified being gravely wronged. Being false accused of being a paedophile, for example, would be a proper example. But if the person really is one and has been convicted of one, well, then they don't have a justifiable sense of being seriously wronged. Okay, so Bowyer, 2013. Defendant knew who the victim was, and then the defendant discovered that was burgling the victim's flat. The victim was very furious about this, so he made some very offensive comment about the defendant's girlfriend. The defendant then lost his cool and killed the victim. The Court of Appeal said this defence won't work for this defendant because he was a burglar and therefore he had no justified sense of being seriously wronged. Now, there are other limitations on these qualifying triggers. Section 55.6 of the Coroners and Justice Act says the following. In determining whether a loss of self-control had a qualifying trigger, A, the defendant's fear of serious violence is to be disregarded to the extent that it was caused by a thing which the defendant incited to be said or done for the purpose of providing an excuse to use violence. B, a sense of being seriously wronged by a thing done or said is not justifiable if the defendant incited the thing to be done or said for the purpose of providing an excuse to use violence. Close quotation. So, I want to kill him. Therefore, I will provoke him so much he says something very offensive to me and I can kill him and get away with it. No, that defence won't work. So how do we explain this? So the defendant strikes the first blow and says something very offensive, verbal or physical blow, and that causes a reaction from the victim, and the defendant says, I can then say I have a qualifying trigger and kill the person. As per Johnson 1989, that defence won't work. And this was also upheld in Bowyer 2013. Okay, sexual infidelity, no, this crime passionnel, that won't work. As Clinton, Parker and Evans 2012, these are cases of this. The Court of Appeal heard this. Okay, Clinton, it says sexual infidelity which leads to a loss of self-control is not a qualifying trigger. But sexual infidelity could provide another trigger which can be considered by the court. So in Clinton, this man, he found his wife, he found out she was committing adultery, but his loss of self-control was there because he wanted to make her decide to give up her lover. She had abused him and made some extremely insulting remarks against him, like she didn't want to look after the children, and she demeaned him, saying he was feeble-minded, and he ought to go and commit suicide. So the court took all this into account, said the totality of that was a qualifying trigger, not the adultery in itself. He was seriously wronged. There have been other cases where people have killed their girlfriend, boyfriend, spouse because of sexual jealousy. Dawes and Hatter, 2013, the Court of Appeal, it said the decision in Clinton was correct, but the trial judge said that the break of a relationship is usually not a sufficient reason to be a qualifying trigger. So this is what the trial judge said in Hatter. To suggest that the fact of a break of a relationship could amount to circumstances of an extremely grave character, or that would entitle the aggrieved party to feel a justifiable sense of being seriously wronged, would be ignore the normal meaning of these words. It would result in the defence of loss of self-control being left to the jury in almost every case where one partner kills in a relationship, kills another. Clearly that is not Parliament's intention. Close quotation. Otherwise, you could never end a relationship where you get killed and the person get away with it. Okay, I think that's enough now about qualifying triggers. Toodaloo.